Wala ko 2 minutes.
So,
Thank you. Government.
lahat may tubig na, may coffee na. Okay na ba? Nagawin na mag-start.
Sino in charge ng social media? Okay na. Ha?
Social media. Like social media strategies na tayo.
Ako rin, di pa lang doon.
Parang pag yung lagi dito ka, may mga 3,000
Ito ko doon nung ako na baka ko. Teenager pa ako.
kung medyo safe.
Ay, pasyalan mo para makita. Ay, nakita mo na ako yung beach. Parang na ako doon. Pero nakita mo yung farms mo. Yung farms mo. Malapit ang bahay mo, di ba? Ay, ito yung makita mo yung farms. Parang yun.
Magpaan na rin.
Yun.
Feel ko rin sarili ko na
Bigla kung saan nang bubili mo, wag yun na.
may nakaraan.
Ang beto yung pagsalito ng bagay na dapat sa'yo.
Kukuha ko ng video. Mag-add na lang ako. Ano ko na sa
Kung ano, dito lang, ano lang, parang parang contract. Ano po siya? Walang contract yan. Bahay lang. Wala pa.
With various other peoples and organizations like I will mention Asian Century Philippine Strategic Studies Institute, Philippines China Mutual Cooperation Society Inc. and others. I'll mention na lang one by one later on when I introduce the families and the actors and when they make the opening statement. We have with us today one of speaker. The topic is very hot and controversial and very relevant to Filipino foreign policy, Philippine economic development future. The topic that we will discuss today, assessing the controversial Supreme Court ruling on the joint marine investment understanding JMSU among the three countries, Philippines, Vietnam, and China, among the oil companies. What are the next moves to be implemented? What should the country go next after the controversial Supreme Court decision? Because welcome Attorney Raul Albino, Chairman of Go for his welcome remarks.
Thank you, Trustee Wilson G. Flores, who is also the current Vice President for the National Capital Region of the Association of Philippines-China Understanding. The other trustees of APCO are here. On the left, we have Mr. Abdul Padrinawa, and we have here Trustee Vic Lavinia, who is also the concurrent Executive Vice President of APCO. And we have also Trustee Hamilton Laguna, who is also the chairperson of the Advocacy Committee of APCO. And down below, we have Henry Guangzong, who is also the second vice chairperson of APCO. And we have our trustee Kwa Cham of the chairperson of the Committee on the Council of Elders of APCO. I was also a professor of law for some time, and I have taught also the subject international law to my students. But I cannot claim to be an expert on international law, as what our distinguished invited speaker today, who can expand further and explain to us the effects of the quote-unquote controversial decision of the Supreme Court, if ever this has been promulgated for everyone's consumption. But he is going to explain to us. Our speaker was also my lecturer in several mandatory continuing legal education that I have attended at the University of the Philippines, or in some other forums, and always he gave us, we lawyers, a better insight of the international agreements, treaties, and other policies of the United Nations and other international agencies. He is also, he was also the professor of my daughter at the University of the Philippines, also graduated law in the same university that he graduated. So we would like to welcome everyone to this very first APCO forum for 2023. We are going to have another monthly forum next month, and again, we would like to invite you to attend this APCO forum, the monthly APCO forum, and the bigger Manila forum, which we hope to hold first quarter or second quarter of this year, with invited speakers from China and the Philippines, experts in their respective fields. The topic today about the effect of the Supreme Court decision on the Philippine foreign policy, on the economic and trade policy, and other aspects of our relations with China, pertaining to the so-called South China Sea, or West Philippine Sea, as we fondly call it nowadays. So again, thank you, members of the media.
Thank you very much, APCO Chairman, Attorney give you all that data for your one-time remarks. Before I introduce our main speaker, I'd like to remind our media friends, tomorrow we shall have another forum here, press conference. It will be by UPO, of course, in partnership with the China embassy diplomats to announce a very important some announcement tomorrow morning. I'll explain later on the details. Let us welcome our next speaker, Attorney Harry Roque, one of the finest legal minds in the Philippines. Also, I read months ago you are also personal legal counsel of our popular President Bongbong Marcos. And of course, he was the courageous presidential spokesman of our record high popular former President Duterte. Let us welcome Attorney Harry Roque for his legal analysis and even political analysis. Welcome, sir.
Well, magandang umaga po sa inyo. Karangalan po muli na makasama kayo dito sa Pantisan Forum. Kalahati po ng bilbil ko dahil sa Pantisan dito sa muling forum. At kasama ang Nesong Puti.
Okay, on your microphone.
Okay naman, narinig ko. Karangalan po muli na makasama kayo dito sa Pantisan Forum. Salamat din po sa APSO. At importante po na pakalakayan. Simulan po natin sa desisyon. Ang sabi ng desisyon, ang constitutional vow ang Joint Seismic Maritime Exploration Agreement na ipinasok ni dating Presidente Gloria Macapagal Arroyo. Ang kasunduan po, pinirmahan 2008 po ata na isang pa ang kaso, and after more than 20 years nagkaroon po ng desisyon. Ang desisyon po ang tratado na pinagkasunduan ng lahat ng mga bansa sa daigdig. Wala pong bansa na magsasabi hindi sila sakop na UNCLOS. Bakit po napakatagal? Napakatagal po nito kasi kada provision, kada artikulo, kada seksyon ng tratadong ito dapat sumangguni o sumang-ayon ang lahat ng bansa ng daigdig. At tawag mo dyan, it was arrived at on the basis of consensus. Hindi po pwede majority vote lamang. Lahat ng bansa pumayag. Bakit po nila ginawa? Kasi sa international law po, meron tinatawag na tratado lamang na ito ay magiging effective lamang sa mga partido ng tratado at meron namang mga tratado na rini-repeat or ini-incorporate yung customary law of international law. Ang pagkakaiba po niya, kapag treaty law lamang, kapag hindi ka miyembro ng treaty, hindi ka sakop ng tratado. Pero kapag ang tratado, restates customary law, then lahat ng bansa, miski hindi yung kasapi, sakop. Pero dito po sa UNCLOS, dahil lahat ng provision ay tinanggap na lahat ng bansa po
ay napapasailalim na UNCLOS. Bakit pa ho sila pumasok sa UNCLOS? Dahil alam natin na sa kasaysayan ng daigdig, kapag hindi malinaw ang mga boundaries, lalong-lalo na sa karagatan, magkakaroon una-una ng digmaan. Pangalawa, meron po talagang tension talaga sa panig ng mga tinatawag na coastal state, yung merong mga karagatan at yung nais na gumamit ng karagatan. In fact, ang panimula po ng international law dahil kay Grotius na nagsasabi na ang karagatan ay para sa lahat at hindi dapat sakupin ng kahit anong bansa. Now, dahil po ito ay isang resulta ng kompromiso, importante na lahat ng bansa ay sumang-ayon sa kompromiso. Anong nilalahad ngayon ng kompromiso na epektibo sa lahat ng bansa? Ang karagatan hinati nila sa iba't ibang mga maritime zones at kada maritime zone binigyan ng kapangyarihan ng coastal state at ang mga third states. Ano ang sakop ng soberenya at ng jurisdiction? Ibig sabihin nito, pwedeng lahat ng batas mapatupad, pwedeng ang pulisya gumana, lahat ng krimen mareresolba ng hukuman ng kanilang mga korte. Yung sakop po ng full sovereignty and jurisdiction ay dun sa internal waters at territorial sea lamang. Ano naman itong territorial sea at ano itong internal waters? Well, meron po tayong tinatawag na baseline. Yung baseline po, kapag ikaw ay archipelago, gaya ng Pilipinas, yung pinakamalayong bato ng archipelago, doon ang baseline. Kukonektahan mo yan ng isang straight line. Lahat po ng karagatan na nasa loob ng baseline, yan ang internal waters. So hindi po pwedeng maglayag ang kahit sinong dayuhang barko sa Laguna Bay. Hindi po pwedeng maglayag ang kahit anong barko sa ating mga lawa. Dahil kinakailangan sumang-ayon ang Pilipinas dahil meron tayong soberenya. Yung territorial sea naman po, 12 nautical miles galing doon sa baseline. Ngayon, full sovereignty, full jurisdiction. Lahat ng batas natin applicable pa rin dyan. Lahat ng hukuman meron dyan na jurisdiction. Ang pulis merong jurisdiction dyan. Pero binigyan ng isang importanteng karapatan ang yung mga naglalayag. Ito yung right of innocent passage. Pwede silang maglayag pero hindi po pwede tumigil at itong pagdaan sa 12 nautical miles na territorial sea ay para lamang sa paglalayag. Hindi pwede mag-research, hindi po pwede magnegosyo, paglalayag lang. Dahil yan yung pinag-aawayan dati ng panahon pa ni Grotius. Yung kagustuhan ng mga maritime powers na makapaglayag sa mga karagatan. Now, bilang kompromiso, hinabaan nila, binigyan nila ng exclusive economic zone ang lahat ng bansa. Pero ang exclusive economic zone, walang soberenya. Ang mga batas, hindi napapatupad, maliban na lang sa batas sa pangangalaga ng kalikasan. Hindi po pwedeng ma-apply ang revised penal code sa EEZ. At kung hindi mo ma-apply ang revised penal code at new civil code sa EEZ, lalong-lalo na hindi mo dapat i-apply ang iyong saligang batas. Ngayon, ang tanong, bakit kasi sa Article 1 ng ating konstitusyon, eminensyon na kabahagi ng national territory yung mga teritoryo na nabanggit sa UNCLOS. Sinasabi ng iba, dahil nabanggit yan sa Article 1 ng Saligang Batas, natural, teritoryo ng Pilipinas yan, kasama na ang exclusive economic zone at dapat mabigyan ng visa ang Saligang Batas. Mali po. Kaya namang in-incorporate yung different maritime zones sa UNCLOS sa Saligang Batas para linawin ng teritoryo ng Pilipinas kabahagi na ang EEZ. Now, nung nabubuhay pa po si Dean Merlin Magallanes na aking professor sa UP College of Law at naging director ng Institute of International Legal Studies, sa kanyang talambuhay, palaging sumusulpot itong archipelagic baselines law na binabago ang teritoryo ng Pilipinas. Hindi ko alam doon sa ating IT kung po pwedeng i-flash yung iba't ibang maritime zones kayo ng Pilipinas na ibinigay ko sa kanya. Kaya bang i-flash? Ha? Kaya ba natin i-flash? Para maintindihan ninyo, no?
Oo, pwede yata.
Para maintindihan ninyo.
Pwede pa set up si...
Oo. Ang unang-unang teritoryo kasi ng Pilipinas, Treaty of Paris, kung saan tayo binili ng mga Amerikano sa mga Espanyol. kwadrado ang ating teritoryo. Ang archipelago kasi, ang common definition niyan, a group of islands and waters forming a unitary whole. So sa kwadradong yan, lahat ng tubig, karagatan sa loob ng kwadrado, tinatrato nating internal waters. Walang po pwedeng maglayag ng walang permiso natin. Bakit? Kasi kung papayagan mo sila maglayag, yung Tanyon Strait na pwede kang lumangoy between Cebu and Dumaguete, ang mga aircraft carriers pwedeng lumangoy, pwedeng maglayag. Bakit? Kasi sa territorial sea, pwede ang mga military vessels o pwede ang aircraft carrier na mag-exercise ng innocent passage. Eh hindi naman po pwede kung internal waters yan. Kaya sa UNCLOS, tayo nag-sponsor ng tinatawag na Archipelagic State Principle. Na dahil tayo archipelago, ay dapat tratuhin nila yung ating karagatan na sa paligid ng ating mga isla na internal waters. Ang problema, nabigo tayo sa UNCLOS. Hindi pumayag ang buong daigdig na maging internal waters natin yan. Pero ang kompromiso, nagkaroon ng archipelagic state. Anong ibig sabihin nun? Ang karagatan ngayon na paligid ng mga isla ay po pwedeng matrato na kabahagi pa rin ng territorial sea pero merong archipelagic strait passage. Ito yung superhighway na hindi po pwedeng saraduhan. Para siyang transit passage. No? Yung transit passage, yung nagko-connect sa dalawang high seas, hindi po pwedeng harangan yan kahit anong mangyari. Unless bobombahin mo mismo yung coastal state, no? Maging threat ka to national security. So yan ang naging na-aproban. Pero hindi mandatory na lahat ng archipelago maging archipelagic state kasi kompromiso nga. Kaya ngayon, ang Japan, hindi siya sumang-ayon na maging archipelagic state. Pero nung pinasa ng Kongreso ang archipelagic baselines law, naging archipelagic state tayo. Dahil may nagkalat ng kasinungalingan na mandatory daw yon. Hindi po. Ang Japan will never become an archipelagic state dahil under UNCLOS, dahil kung yan ay mangyayari, yung aircraft carrier ng China po pwede na maglayag sa internal waters, sa archipelagic waters ng Japan. So hindi po totoo yan. Kaya lang, hindi kami napakinggan. Kaya ang ginawa namin, dumulog kami sa Korte Suprema. Bakit? Kasi po, yung kwadradong tubig under Treaty of Paris, napakalaking internal waters at territorial sea yan. Kasi lahat ng tubig sa loob ng kwadrado, internal waters, walang paglalayag ng dayuhan. Ang territorial seas natin, doon pa lang 12 nautical miles sa kwadrado. Ang sabi naman ng mga nagsusulong ng archipelagic baselines, no, kasama na po si Justice Antonio Carpio, ay hindi. Kailangan sumunod tayo sa UNCLOS. Tama po yun. Except that as a matter of compromise, hindi obligatory, hindi mandatory kung ikaw ay archipelago na maging archipelagic state. Again, Japan is not an archipelagic state under UNCLOS and cannot be compelled to do so. Natalo po kami sa kasong yun. Bakit? Dahil ang sabi ng Korte Suprema na nakaupo po doon, kung alam kung si Justice Carpio ang ponente, wala raw pagbabago sa teritoryo pero kinakailangan natin ipatupad ang ating obligasyon sa ayon sa UNCLOS. Ang sabi nila, walang teritoryong nawala. Hindi po totoo yun. Kasi ang nawala sa atin, internal waters at territorial sea na mayroong soberenya at jurisdiction, ang sabi ni Justice Carpio, in exchange, mas malaki ngayon ang karagatan natin. Exclusive economic sea zone. In the first place po, even without the archipelagic baselines law, si Presidente Marcos, meron ng PD na bumuo na exclusive economic zone natin. At saka hindi po apple for apple yan. Dahil ang EEZ, walang soberenya. Sovereign rights lamang maghanap at pumalap ng tanging yaman sa EEZ. So yan pong estado ngayon. Magalyona versus Executive Secretary, kinakailangan sumunod sa obligasyon sa tratado, bagamat ang aming punto de vista, yung pagsunod sa tratado, rinirespeto naman ang karapatan ng mga archipelagos na magdesisyon kung gusto nila maging archipelagic state or hindi. Hindi siya mandatory. Kaya ang sinasabi ko, mali ang desisyon. Dahil sa exclusive economic zone, walang soberenya, hindi po dapat bigyan ng aplikasyon ang saligang batas, hindi dapat bigyan ng 60-40 rule ang exploration and exploitation of natural resources sa exclusive economic zone. Now, hindi pa pagtataksil sa bayan niyang posisyon na yan. Hindi po. Bakit? Unang-una, malinaw po sa Magaliona versus sa Executive Secretary na tinatanggap ng ating hukuman na dapat sumunod sa UNCLOS. Bakit ngayon, yung nawala sa atin, karagatan na merong soberenya at merong jurisdiction, pinayagan nating mawala, ngayon, exclusive economic zone, nag-i-insist tayo na magkaroon ng soberenya. Unang-unang implikasyon kapag itong desisyon na ito hindi na bago. Madidemanda po tayo sa UN Tribunal for the Law of the Sea. Because ang pagbigay visa sa saligang batas na 6040 rules sa exclusive economic zone ay labag sa UNCLOS na pinasok natin. Hindi po pwedeng bigyan ng effectivity ang saligang batas, ang revised penal code, ang new civil code sa exclusive economic zone. Pangangalaga lamang ng kalikasan at pangangalap at pag-exploit ng tanging yaman lang ang nasa exclusive economic zone. Madidemanda tayo, mapapahiya tayo sa UN Tribunal for the Law of the Sea. Pangalawa, binigyan natin ng armas ang China na bigyan ng effectivity ang kanyang laws on national territory doon sa pinag-aagawan. Sinasabi nga natin China, sinabi na nga na walang visa yung iyong claim to historic waters. Pero kung tayo mismo sa ating gawain ay lumalabag sa UNCLOS, bakit naman susunod ang China sa UNCLOS? Pareho naman tayong lumalabag dahil ini-insist din natin na subject to constitutional law natin ang EEZ. Di ba po? He who comes to court must do so with clean hands. Pero kung tayo mismo ang lalabag sa UNCLOS na sinasabi natin na dapat sundin ng China at yan naman ang desisyon ng tribunal dahil ginagawa niyang municipal waters because of historic title na walang gano'n naman sa UNCLOS, bakit naman tayo pagbibigyan? Tayo lumalabag din sa UNCLOS. We can never go to court now as far as the islands are concerned with unclean hands. Dahil tayo mismo lumabag sa kasunduan ng UNCLOS. Ang pangalawa at mas importante siyempre na implikasyon na yan, tatagal ang hidwaan natin sa pinag-aagawang teritoryo. Alam mo, sa Harvard merong course on conflict resolution. And basic rule in conflict resolution is always have as many options as you can. Kasi hindi po pwede isang partido lang ang masusunod. Yung joint exploration could have been a feasible alternative. Huwag natin pag-usapan ng soberenya kasi wala naman soberenya sa EEZ to begin with. Pag-usapan natin paano tayo makikinabang. Pangalawa, hindi naman ngayon lang nagkaroon ng joint exploration agreement. Halos lahat ng bansa sa Middle East meron. Bakit? Ang langis kasi sa ilalim ng lupa, wala namang boundary sa ilalim ng lupa So they have to share it. Yung mga rivers, yung River Nile, yung Mekong River, they all enter into a joint exploration agreements. At siyempre, yung pinasok nating joint exploration agreement is not the first involving China. Even Vietnam, which is more belligerent to China on the territorial dispute, has an existing joint, not just fishing agreement, but also exploration agreement for natural resources. Hindi po tayo nag-invento ng joint exploration. Matagal na pong ginagawa yan ng mga estado dahil alam nilang mas mabuti na makinabang na ngayon kaysa humaba pa ang hidwaan. At pangatlo, dahil hindi mariresolba ang pinag-aagawang teritoryo, hindi tuloy makikinabang si Juan de la Cruz sa napakadaming inaasahang natural gas at oil dyan sa Recto Bank. Ang estimate po ng mga dalubhasan na basa ko, 5 beses, yung 5 times more deposit ang Recto Bank than Saudi Arabia. Ayaw na mga kalaban ng Joint Exploration Agreement na maging kasing yaman ng Saudi Arabia ang Pilipinas ay stand corrected. Mas mayaman pa na dihamak sa Saudi Arabia dahil sa tanging yaman dyan sa Recto Bank. Dahil meanwhile gusto nila mapatuloy ang hidwaan. Tapatan po ang Joint Exploration Agreement siguro po pinasok sa parte ng Pilipinas at mga Amerikano, hindi siguro sila nagreklamo. Pero ang punto naman, Paano naman mangyayari yun ng mga Amerikano makipag-joint exploration agreement sa China, mainit nga ang kanilang relasyon. Ito pong pag-o-oppose nila, it is because ayaw nilang maging kaibigan natin ang China at gusto nilang pumanig tayo sa Estados Unidos. Pero sa akin naman, ang dapat nang isulong kung anong mas mabuti sa interes ng mga Pilipino, kung ang joint exploration magre-resulta sa mas maraming pagkain sa hapagkainan, so be it. At sino ngayon ang hindi nagmamahal sa taong bayan? Yung gustong hindi makinabang ang mga Pilipino o yung gustong maging mas mayaman na ang mga Pilipino? I rest my case. Magandang umaga po sa inyong lahat.
Uy, ang galing talaga ni Attorney Harry Roque. Brilliant and eloquent. Alam niyo, Attorney Harry Roque, alam ko, magaling din sa government kasi you graduated from London School of Economics and University of Michigan, pero pag managalan kayo, we are speechless. In geopolitics, economics, ba't wala kayo sa gobyerno? Ba't in the government? People miss you. Thank you. We will go later on to question and answer, but before that, we have two reactors to talk. Ang reactor natin, ang una, nasa tabi ko dito, si Mr. Adolfo Paglinawan. He is a former diplomat, Filipino diplomat based in Washington before, former journalist, book author, geopolitics analyst, and now Vice President for Internal Affairs of the Asian Century Philippines Inc. But more important, newly elected trustee and director of Association for Philippine-China Understanding, APCO. Mr. Adolfo Paglinawan, for your reaction to the eloquent talk of Attorney Harry Roque.
Good morning to all of you. It's very hard to react to this because Attorney Harry Roque took away 95% of my presentation. So I will deliver a reaction as Harry Roque asserts it is wrong, superfluous, and non-sequitur. In fact, I consider it that the Supreme Court, in ruling on the JMSU, legislated a dangerous precedent based on fiction, a fiction of fact and a fiction of law. That is why, to my mind, I wonder how 12 Supreme jurors is in error. In this case, a statistical improbability. As they say, something must be rotten in Denmark. Cannot be taken at face value, however, because it is not reflected vested interest. It's time to take advantage of this rule to sabotage the proposed joint oil and gas deal with China and our two national interests, which have been enumerated by the honored speaker. Be that as it may, as he has asserted further, that the Solicitor General must file for a motion for reconsideration to correct this judicial mistake to begin with. The ruling stretches and violates the definition of territorial seas by the United Nations Convention of the Laws and stretches the inclusions within exclusive economic zones. EEZ entitlements involve sovereign rights, as he says, not sovereignty. Is that it? Thus, EEZs do not create territorial seas. At its worst, and in very real sense, the JMSU ruling poisons the waters. And sadly, Our president has just arrived with the good news and glad tidings from our neighbor, which has now become a superpower. But I'd like to mention what has been missed. In Article 55, Section 2 of UNCLOS, it reads, in exercising its sovereign duties under this convention in the exclusive economic zone, the coastal state shall have due regard to the rights and duties of other states and shall act in a manner compatible with the provisions of this convention. I wish to repeat, the coastal state shall have due regard to the rights and duties of other states. I have written 4 articles in the Asian Century Journal last September 2022 that with this decision notwithstanding, I have forwarded 4 theories in 4 articles which I have given in my paper submitted to you. I will no longer discuss them. We allowed the Americans and the Anglo-Dutch to milk us in Malampaya, in Palawan, exceeding up to 90% of benefits derived from natural resources within our sovereign jurisdiction. We even carried it to the burden of paying their taxes. But we fiddle on the roof, so to speak, when the Chinese are only asking for 40% outside of our territorial seas. I cannot understand this, Mr. Roque. That's why in my first book I said, the Filipino has a problem for every solution. Our history is replete with nightmares where laws have been used to obstruct the nation's progress and development. And this is why many of our citizens live in abject want. So I ask, what good are laws that sentence human beings to pernicious poverty? And this latest act of the Supreme Court has become very suspicious, I repeat, because how, to my mind, can 12 Supreme jurors be in error is a statistical improbability. As they say it, something is really rotten in Denmark. Thank you.
Thank you very much, Mr. Ado Paglinawan. Next reactor natin, Mr. Peter Labinia is the chairman of the Philippine-China Mutual Cooperation Society, Inc. He is from Davao, a civic leader, a former councilor, and he, I remember, was also spokesperson of the campaign of then presidential candidate Rodrigo Duterte. He is also, more importantly, just elected as Executive Vice President of the Association for Philippine-China Understanding, or APCO. Let us welcome Mr. Peter Labinia for his reaction.
Thank you. Thank you, Wilson. Good morning, everyone. Chairman Raul, Spokes Hari, Ado, and Kamentong. I am speaking in behalf of the Philippines-China Mutual Cooperation Society. This is a group of Binondo-based, and but our organization is also nationwide, promoting business-to-business and people-to-people relations with China on the banner of cooperation instead of conflict. Our reaction on the issue about the recent Supreme Court decision is one of support with the views expressed by Professor Hari and Kaado. We believe that the ECC is not covered by our Constitution and that we should promote joint exploration and development of our natural resources in these areas. We are facing a grave problem about climate change. And our country is also pursuing the decarbonization of our energy. Maybe in the next 40 to 50 years, we have to reduce and limit the use of fossil-based energy. While we are pursuing renewable energy as an alternative, but we are not in a position to immediately replace fossil-based energy. Liquefied natural gas is the transition energy that we should use. And as pointed out, areas within our territorial boundaries as well as in our ECC has rich natural gas resources, and we need to exploit these resources. Our call is for an all-nation, all-government approach to address this energy problem. And we call on all the Filipino people, all the instrumentalities of our government to unite, be one in addressing this problem. So, the decision of the Supreme Court we see is a block or roadblock in pursuing this joint exploration and development of a vital resources for our development. Exploiting and developing these natural resources will not only assure our self-sufficiency in our energy needs, it will provide us with a vital capital, as pointed out. The rich natural resources there could provide our country with a much needed capital for further development. So on this regard, we are supportive of efforts to call on the motion for reconsideration, no? So that members of the Supreme Court were seeing these lights, no? That we need badly our natural resources in this ECC. Thank you and good morning.
Thank you very much, Mr. Peter Lavinia. Before we go to later on the closing remarks by Mr. Herman Laurel, we have time for questions for Secretary Harry Roque. Microphone please, pakiabot lang. Paki-introduce yourself.
Hi, good morning. I'm glad to see my favorite spokesperson,
Thank you, sir.
Secretary Harry Roque, and one of my professor in college, Attorney Raul Lambino, political
Wow,
science
professor talaga
professor.
to. Bukas ang bata.
Okay. Sir, I would like to address my question to spokesman at kay Secretary Harry Roque, kasi nasanay na kaming secretary. Okay, sama na yung press corps. Okay. Secretary, alam naman natin na mayroon kayong doktrina sa kayong mga abogado. Right or wrong, the Supreme Court is always right. Tama po, di ba?
Correct.
Dito sa decision nila, na talagang nakikita natin na mayroon talagang pagkakamali. Ang tanong ko po, ano na ang mangyayari doon sa, during the time of President PRRD 2018, kung hindi ako nagkakamali, nung magkaroon ng state visit dito si President Xi Jinping, na ayaw ko kung kayo na po yung spokesman or Attorney Panelo, nagkaroon ng joint yung Memorandum of Understanding nagpirmahan, that was 2018, regarding the joint exploration between the People's Republic of China at saka ng Pilipinas doon sa mga natural gas or oil doon sa South China Sea or West Philippine Sea. Dito sa ibinabang desisyon ng Supreme Court, tapos kagagaling lang ni Presidente BBM sa China, ang ganda ng dala niyang palita, inilabas itong desisyon ng Supreme Court na, now, my question, what will happen to that Memorandum of Understanding?
Well, linawin ko lang po, yung pinasok ng panahon ni Presidente Duterte is a framework agreement where the Philippines and China agreed to negotiate towards a treaty that would enable their citizens to explore and exploit for natural resources. Ito po yung natigil. Kaya naman po tinigil ni Presidente Duterte yan, paalis na siya sa pwesto. And did not want really to tie the hands of his successor regime. No? Kasi otherwise, baka mapulaan din na midnight deal yan. No? So, hinayaan na niya ang Marcos administration na magpatuloy kung gusto ng Marcos administration. At nagsabi naman po ang Presidente PBBM na gusto niyang ituloy. So, ang sagot ko po sa inyo, wala pong epekto, but kung talagang hindi mababago itong desisyon nito, malilimitahan kung anong po pwedeng pagkasunduan. Kapag ito po hindi nabago, ma-apply po natin yung doctrine na sinabi rin ng Korte Suprema na ang foreigners can only explore and exploit through an FTAA, yung Financial Technical Agreement. So, babalik tayo doon sa FTAA regime, no? Dahil yan lang yung tanging pamamaraan para makapasok ang mga dayuhan. Pero yung kaso pong yun, na sinabi na hanggang FTAA lang ang mga dayuhan, applicable po yan sa land territory at saka sa territorial sea. Kasi yung kaso pong yun, minahan sa lupa. So, subject to full sovereignty and jurisdiction, kaya in areas subject by full sovereignty and jurisdiction, kasi land territory yan, hanggang FTAA lang ang mga dayuhan. Dapat po, hindi sakop ang EEZ. Pero siyempre, kung hindi mababago to, wala na pong pag-asa ang Joint Exploration Agreement with China unless China will agree on a 60-40 basis, which I doubt, of course.
Okay. Follow up, Secretary Roque. Sir, alam naman natin na kaya ng sinasabi doon sa papel ni Sir Ado Pagkalinawan, na anong dahilan bakit yung 12 mahistrado ng Supreme Court na alam naman natin hindi matatawaran ng kanilang katalinuhan, bakit sila nagkamali na itinuring nila na yung exclusive economic zone natin ay nag-exercise tayo ng sovereignty sa halip na sovereign rights?
Well, sa akin po, napakatagal na tulong ang kaso. At ang sa akin, lumabas ang desisyon, I'm not commenting, I'm not answering you. Because I think it will be disrespectful naman for anyone to impute motives, no, on the Supreme Court. Pero the timing to me is too much of a coincidence. Parang sinampal ang presidente after he reaffirmed his commitment to explore settlement for a peaceful solution to the West Philippine Sea, among others, through a joint agreement. Sampal na malaki po yan sa mukha ng presidente. But I will not ascribe ill motives sa ating Korte Suprema. Kaya nga po mayroong motion for reconsideration para mabigyan naman ng pagkakataon na iwasto ang pagkakamali ng Korte Suprema.
Ang Solicitor General po ba ay gumawa na ng aksyon para mag-file ng motion for reconsideration with regards to his Supreme Court decision?
Ang problema po, sagutin ko lang ha, ang problema po, wala pa yung desisyon eh. Ay kahapon, nakausap ko si ES,
Wala pa.
dating CJ, sabi ko bakit pa sila na-press briefing? Wala pang desisyon na in writing. Sabi niya, yun yung patakaran sa Supreme Court. Pagkatapos ng butuhan, gagawa na ng press release. Eh sa akin, mas mabuti pang isabay na. Kasi ngayon, hindi natin alam kung anong basihan. Naghahaka-haka lang ako kung anong dahilan nila. In-apply nila yung saling kapata sa EEZ, pero walang kasiguraduhan. So ang aking suggestion as an officer of the court, wala namang mawawala kung isabay na nila yung press release, maglabas mismo ng mahimay-himay ng mabuti ng taong bayan yung desisyon.
Secretary, follow up to the question niya, similar. Tatlo ang nagtanong na journalist, sabi nila, iba na sa Zoom, iba na sa Facebook Live. Anong recommendation niyo to the legal, to the Justice, the Solicitor General of President Bongbong Marcos? Ano ang next step of the government to remedy, if ever, this controversial decision?
Meron naman tayong 15 days from the time of receipt of decision na wala pa nga kasi wala pa rin sa internet. No? Kapag meron naman decision na yan, ina-upload nila sa internet para mag-file ng motion for reconsideration. But my advice to Solgen na Maynard is of course to appeal this kasi anong epekto nito? Ginawa nilang inutil ang presidente as chief architect of foreign policy dahil they limited the options available to the president. Eh yan naman, ay executive function, hindi naman judicial functions yan. At saka malinaw kasi sa tratado na hindi dapat ina-apply ang internal laws sa EEZ. Same
at saka sovereign rights. Kahit basahin mo yung saligang batas natin, wala kang makikitang words na sovereign rights. Ang makikita mo doon, sovereignty and jurisdiction. Pero doon sa clause, nakalagay yung sovereign rights dahil magkaiba yung karapatan ng bansa sa sovereignty and jurisdiction. Sinabi na niya kung ano yung mga mag-a-apply doon, revised penal code, civil code, constitution. Kung sa sovereign rights, binanggit na rin ni Professor Haro na ito ay cover sa protection ng environment at saka other economic benefits ng mga ibang mga bansa na kung minsan nagkaroon ng overlapping. Mayroong tinatawag kasi na prinsipyo sa constitutional law, yung doctrine of incorporation at saka doctrine of transformation. So under the doctrine of incorporation, yung provision ng international law automatically incorporated sa ating saligang batas. So kung yung 1987 Constitution as my novelty, isa sa doon sa gawa ng UNCLOS, so lahat ng provision ng UNCLOS automatically incorporated sa 1987 Constitution. Iyon ang ating sigurong tignan na siguro, ang gagaling naman ng ating abogado sa Solicitor General's Office, makikita nila yung pagkakaida ng definition ng ating sovereignty and jurisdiction at saka sovereign rights. So, yan siguro ang pagkunan natin kasi pero napakaganda yung paliwanag ni Secretary Roque yung repercussion nito sa ating foreign policy dahil ang Panginoon siya yung chief architect ng ating foreign policy. Siyempre yung epekto dito sa ating trade and economic relations with China and Vietnam. Hindi lang isang bansa ang apektado rito na ating kaibigan na rin ang China at saka Vietnam. At saka meron pa kang iba na mga conflict areas diyan sa China Sea or West Philippine Sea. So, yun natin ito. Salamat. Sir, isa na lang actually, yung expert in international law, ito na talagang gusto itanong. Kasi, hindi kaya yung nakagulinan, yung nagkaroon tayo ng exclusive economic zone. Dinito nila, this is your 200 exclusive economic zone. Ang aring nilang exercise dito, sovereign rights, yung sovereignty ninyo wala dito dahil nandun sa territorial waters ninyo. Hindi kaya lalo nakagulinan yung kakaroon natin ng exclusive economic zone, which is 205. I would say no.
Bakit? Kasi merong obligation to negotiate kapag nag-overlap ang EEZ. Talagang first, you rely on mediation and conciliation. Kung hindi papasok yan sa mediation and conciliation, dyan papasok ang dispute resolution mechanism either through UNCLOS, tribunal, or the World Court, the ICJ. Or kung hindi pumili, then it will be resolved through ad hoc bilateral arbitration. So in the sense na talagang magkakaroon ng overlaps na napakalawak ng EEZ, yes, no, parang magkakaroon ng conflict, magkakaroon ng overlap. Pero meron din mekanismo to resolve it. So it does not have to be mas magulong as you said, no? Because there is also a binding provision on conflict resolution. Kaya ito yung basihan nga kung bakit nag-assume ng jurisdiction ang International Tribunal for the Law of the Sea even if China said they are not covered by the arbitration. Now, take note po, bagamat China insists that it is not covered by the decision, they're complying with it. How? Joint fishing in Scarborough Shoal. Dati pinagbawal. Ngayon, hinahayaan. Dati, nag-ano sila, nag-fishing method sila na sabi ng Tribunal for the Law of the Sea is in violation of the provision on marine conservation under UNCLOS. Natigil yun. So states will never agree that they violated international law, but because they are civilized, they comply with international law.
Thank you, Secretary. May tanong si Mr. Laurel. Yes, Mr. Herman Laurel. If I recall correct. Hello. Yeah, if I recall correctly. Okay. One of the points China has been making is that the Philippines and China never went through mediation before going into the arbitration panel. Is that correct?
Hindi po. This is where Justice Carpio and I differed. Ang sabi kasi ni Justice Carpio, dapat conciliation. He went on record po in a speech before Ateneo de Davao that the solution was conciliation. In my MCLE lectures, as mentioned by Secretary Lambino, I said no, conciliation will not lead to anywhere because if the parties do not agree, then the problem remains. It has to be arbitration because arbitration is binding, and all parties that ratified UNCLOS are subject to the mandatory dispute resolution mechanism. No? So, yun po ang aking sagot dyan. I think China is a friend of the Philippines, and gaya na aking sinabi, they maintain it's not binding on them, but they have been following the rule. Thankfully.
Attorney Roque, ito po bang application ng 200 nautical miles sa CCC ay automatic? Or as in the case of Benham Rice, ano ang ating naging procedure dyan para talagang magkaroon tayo ng undisputed, exclusive economic zone dyan?
Well, ang EEZ po is actually mandatory. There is only one optional maritime zone, and that is the contiguous zone, which is a further 12 nautical miles from the 12 nautical miles of territorial sea. That is optional. At ang covered lang po ng partial sovereignty in the contiguous zone are fiscal laws, yung smuggling, yung anti-counterfeiting, monetary, and of course, environment. No? But the only optional is the contiguous zone. So all countries are entitled to an EEZ by way of a compromise nga. Limited jurisdiction and sovereignty, but expanded economic benefits with built-in conflict resolution mechanism, realizing that the scope and breadth of the EEZ will lead to overlaps.
Thank you. I think we have no more time because the APCO officers here, led by Chairman Attorney Lambino, will have a lunch meeting later on for taking with the former president. So, may tanong. One last question. Yes, for Mr. Laura. Yeah. One or two more. Yes.
Can the president refer this to the people through a referendum?
Well, my point of view is UNCLOS is mandatorily applicable to Philippine territory. In fact, dun sa kaso ng Magaliona, ang sinasabi ko, there is nothing to compel us to become an archipelagic state because pursuant to UNCLOS itself, you must deposit your base points and baselines if you agree to become an archipelagic state. So by not becoming an archipelagic state, you do not violate the UNCLOS. Ang masakit nito, when we argue the case of Magaliona, ang sabi ko pa, there is another customary law principle that will justify our quadradong Treaty of Paris boundaries. What is that? Uti possidetis iuris. Colonial boundaries must be respected. And of course, the Treaty of Paris was not only a recognition by the Philippines, Spain, and the United States. All the other Europeans in the region recognized the boundaries of the Treaty of Paris. So that is a classical example of territories recognized by international law, even if it is not compliant with UNCLOS, but justified by another legal principle, uti possidetis iuris. So, submitting it to the people, well, I don't think it will matter because the Supreme Court has already recognized that UNCLOS is binding on us. And if you look at the intention of UNCLOS nga, the intention kaya pagkatagal-tagal na panahon ng lumipas bago natapos ang UNCLOS na yan is so that no country can claim it is not binding on us.
Thank you, Secretary. There's a question here from a journalist. Is it true Vietnam also occupies a lot of islands with overlapping disagreements with the Philippines? But how come all the media reports, all the complaints of politicians, puro only about China, nothing about Vietnam, Taiwan, Malaysia, Brunei? It's very weird now. How come it's always now China? Is it true that Vietnam occupies a lot of islands also?
Alam nyo kasi ito, although there are 5 claimant states, iba-iba naman yung islang kiniklaim natin. It's actually 5 different claims, pero 5 bilateral claims. Kasi yung Paracel Group of Islands, di natin kiniklaim yan. Yan ang talagang kiniklaim ng Vietnam. Except that, we lost Miss Chief Shoal, if I'm not mistaken, initially to Vietnam. Bakit? Nakipaglaro yung mga sundalo na Vietnamese. Tapos, hindi na umalis mga Vietnamese. But now, it's also under possession of Pugat Island ba yun? Anong tawag sa English ng Pugat Island? Baka nagkamali na ako. Ano yun? Nandito si Dr. Patoy.
Dr. Professor Van Lawi. Yes.
Oh.
Baka, sige, microphone. Professor Romel Van Lawi. Microphone.
Kasi anyway, may isa tayong isla na nawala sa atin dahil nakipaglaro yung mga sundalo natin sa Vietnam, hindi tayo pinabalik. Okay? Isa lang yun. Pero basically, ibang cluster of islands ang pinaklaim natin. Ang advantage natin, ang mga Southwest Cape pala yun, no? Ang pinaka malapit na estado sa mga disputed islands, Pilipinas. Tayo lang, ang lahat ng isla na inaangkin natin except for Ayungin, isla talaga kasi permanently above water. Ayungin kasi iba yan, kasi so lang yan, talagang underwater yan. Okay?
One last question. Yes.
Ngayon, doon sa 2016 na arbitral award natin,
pinahina. Bakit? Ang sabi ng arbitral award, China, sumunod ka sa UNCLOS. Ano ang ginawa ng Korte Suprema sa decision nito? Hindi kami susunod sa UNCLOS, ipapatupad namin ang aming saligang batas. Ngayon, sasabihin ng China, o kita nyo, pinipilit nyo kami mag-comply na wag sundin ang aming mga batas na internal. Eh bakit ang Pilipinas ganun din? Etong desisyon ng Korte Suprema nila. So ngayon, sasabihin ng China, wag na natin papaano yan, patuparin. Kasi hindi rin naman sumusunod ang Pilipinas sa UNCLOS eh. Remember, he who comes to court must do so with clean hands.
Alam niyo, marami na gusto maging abogado dahil sa eloquence ni Secretary Harry Roque. You are so brilliant. Grabe. Alam mo, maraming taong di nakakaalam, grand uncle niya si brilliant Senate President Jovito Salonga. Grabe. We have time for a final, before the closing remarks of Mr. Herman Laudel, we'd like to request Secretary Harry Roque to give us, can you summarize, sir, your points? Secretary, like your appeal to the public, to the justices, to the government, anong final message yun to wrap up everything? Brilliant speaker.
The beauty of our judicial system is there is an opportunity to rectify mistakes. The decision, albeit flawed and erroneous, can still be corrected through the filing on the part of the Office of the Solicitor General of a motion for reconsideration. Sana po, maihain yung motion for reconsideration na yan dahil at stake po rito ay hindi lamang ang tratado ng UNCLOS kung hindi ang mas mabuting buhay para sa lahat ng Pilipino. Nais ko na pong maging mayaman, mas mayaman pa kaysa sa mga Saudi, pagbigyan po natin itong pagkakataon nito.
Thank you very much to the very outstanding former Secretary and legal luminary, Harry Roque. Before we go to the closing remarks of Mr. Herman Laudel, i-announce natin ang APCO event tomorrow. Association for Philippine-China Understanding and the Embassy of the People's Republic of China are inviting the media tomorrow to a media forum to launch and call for nominations for APPCU 2023 award. It will be here 10 a.m. at Kamuning Bakery Cafe. This will be a hybrid media forum, Zoom and actual physical face-to-face. The officials attending tomorrow, of course, dito, APCO Chairman Attorney Raul Lambino, APCO Co-Chairperson and APCO President Sixto Benedicto, APCO Executive Vice President and Official Spokesperson of the APPCU 2023 Award, Peter Labinia, together with top China diplomat na newly posted here in Manila, Councilor G. Councilor G. Lengpeng, Councilor for Media and Public Relations. Please attend tomorrow.
Before we go to the closing remarks, I just would like to acknowledge, gusto ko lamang po pasalamatan si Professor Romel Banlawi. Isa po siya sa aming naging laureate or awardee po ng APCO, yung Association for the Promotion of Philippines-China Understanding. Of course, ang aming bagong trustee, si Trustee Pagkalinawan at saka si Trustee Camintong Laurel. Mga awardee na po sila ng APPCU. Yun po yung ilo-launch namin. Bukas po yun dito sa Kabuning Bakery, yung 2023 APPCU. Salamat po.
Thank you very much. Of course, the next speaker is for the closing remarks. He himself, Mr. Herman Laurel, is an awardee of APPCU, also nationalist intellectual, and also he is the president of the Asian Century Philippine Strategic Studies Institute. For closing remarks, Mr. Herman Laurel.
Nagpapasalamat po ang Asian Century Philippine Strategic Studies Institute sa tulungan po ng iba't ibang mga organisasyon na naghahangad ng pagkakaunawaan at pagkakasunduan ng China at ng Pilipinas, represented by APCO here, by TCMCS, Philippine China Mutual Cooperation Society, which you will hear more of in the coming weeks and months. And of course, Pandesal Forum, Kamuning Bakery, and our distinguished guest, Attorney Harry Roque. I'd like to fill in a few points lang. Remember that in May of 2022, President Duterte then reminded the nation to honor the commitment to this oil and gas deal, which was reversed in June of that year, the first week of July of that year by Teddy Boy Locsin. I'd also like to mention the joint ventures of China and Vietnam, which includes the Beibu Gulf Joint Oil and Gas Exploration. So this is an actual joint exploration of Vietnam and China. And the Petro Vietnam and CNOOC, the state oil company of China's joint venture in the South China Sea. So cooperation is the name of the game today. And with that, I'd like to say that we end this discussion this morning. Thank you for the participation of media, and we hope you help disseminate this information so there will be more understanding of the implications and what the nation and the President BBM government can do about this dilemma presented by the Supreme Court decision and timely announcement of this decision of their decision on the JMSU. Thank you very much.
Thank you very much, Mr. Herman Laurel, and all the other speakers, of course, led by the extremely eloquent, enlightened main speaker, former Secretary Harry Roque, APCO Chairman Raul Lambino, Mr. Ado Paglinawan, Mr. Peter Lavinia, Mr. Herman Laurel. We'd like to make special mention of three APCO officers below who we will invite here, plus of course the awardee, Dr. Romel Banlawi, from Cebu, Director of APCO, Felix Guanzon. Thank you for being here. And also Director Mr. Kwa Ching Tan, an intellectual and writer and historian. Can we invite the three of them, including future Dr. Ana Malindog Uy, also Director and Trustee of APCO, and also can we invite them all here? Can we invite all of you here for pic-taking with our pandesal? Picture taking tayo? Yes. It's a tradition here whether you are movie stars or presidential candidates or ambassadors, we give you pandesal here. Yes. Yes. Thank you very much. Let us encourage dialogue and cooperation and economic development. Thank you to everyone for being here. Lunch will be served. Please, yung mga media friends natin, please sit down. Lunch will be served with coffee and drinks. May lunch tayo, please. Sit down lang kayo. Relax only. Ito go. May induction. Thank you. Why you look at here?